Thank you for joining us and welcome. My name is Dr. Ebony Birchall. I'm the Deputy Director of Macquarie University's Business and Human Rights Access to Justice Lab, and I'm going to be moderating today's discussion. Before we start, I'd like to acknowledge the traditional owners of the lands on which we meet today. So I'm speaking from the unceded lands of the Gadigal people of the Eora Nation, and I pay my respects to elders past and present. And I want to extend that respect to any Aboriginal and Torres Strait Islander people who are joining us today. And I also acknowledge that we are all joining from different places. So I know there's a lot of people from Australia, but there's also people from Thailand and then other parts of the world as well. So we're delighted to have three leading practitioners working at the intersection of human rights advocacy, strategic litigation, and corporate accountability in our region. So first, we've got Emilie Palamy Pradichit, so founder of and executive director of Manushya Foundation. Thanks for joining us, Emilie. We have Nicki Lees, Social Justice Special Counsel at Maurice Blackburn Lawyers, and also Keren Adams, Principal Legal Director at the Human Rights Law Centre. So thank you so much for each of you for being here. What we're going to do today is we're going to start off with a chance to hear from each of our panelists individually. And then we're going to do a bit of a panel discussion on some of the core questions that this case raises. And then for the last 10 minutes or so, we're going to have an audience Q&A. So please do post in the Q&A function of the Zoom webinar your questions throughout the conversation. Just leave them in the Q&A box and they'll sit there and they'll be ready for us once we get to the Q&A section at the end. Yeah, so I think that's all of our housekeeping, and we're ready to start. So I'm going to hand over to Emilie first to talk to us about the case. So could you walk through the case, what the court decided, the key significance of this case, and maybe a bit about what comes next? And Emilie has very kindly made us a presentation. So thank you, Emilie. I'll hand over to you.
Okay, thank you very much. Thank you very much, Ebony. Thank you also to the Macquarie University Business and Human Rights Access to Justice Lab, for organizing this important discussion. It's also a real pleasure to be joined today alongside Keren and Nicki. So today I really want to share not only about a legal victory, but it's really about a victory and story on power. And it's a story about what happens when ordinary villagers, challenge a multinational mining company, survive more than a decade of litigation, survive more than 40 slap lawsuits, and ultimately win. And so this case is not simply about gold mine, but it's really about whether communities can hold powerful corporations accountable when governments, permits, institutions, and even parts of the justice systems have failed them. And so, as you know, this is the first environmental class action victory. This is really for the first time in Thailand, environmental class action succeeded against a major corporation. This is the biggest gold mine corporation in the country. And so the court found Akara Resources, a subsidiary of Australian Kingsgate, consolidated liable for environmental contamination and harm suffered by local communities. And ultimately, 382 villagers won. But what matters is not simply the number. It's really what matters in this victory. Really, it's about the accountability that was made possible. Because for decades, communities across our region in Southeast Asia, have been told that multinational corporations are simply too powerful to be challenged. And so these judgments really proves otherwise. It's the subsidiary company, of course, that was held accountable. But it's really a victory that was not won in court alone. It was really won because communities combine litigation, grassroots mobilization, international advocacy and accountability, and persistence over more than a decade. And so, who are the communities behind the case? So the communities behind the case are. It's important for us to discuss the people before we can discuss the law, right? So the affected communities live in Phichit and Penchabun provinces. Like you can see, we have we put a map of Thailand so you can see those two provinces are located in central Thailand. And so they are farming communities. And so people depend on the land, the water, the rivers, ponds, agriculture, and natural resources for survival. The Chatri gold mine began operating in 2001. And for years, villagers reported contamination concern. The company has got permits and the company complied with the regulations. Everything was safe, according to the company. Meanwhile, villagers watched the environment change around them. And so the crops were affected, the water sources became suspect, and the confidence in the safety of the food disappeared. And so for years, communities were told to trust paperwork over their own lived experience. It's also important to note that from 1st January 2017 to 21st March 2023, the mine was closed following complaints by villagers. The head of the NCPO, the prime minister of that time, decided to take an order and to close the mine. This was followed then by an international arbitration initiated by Kingsgate under the free trade agreement between Thailand and Australia, the TAFTA. And so Kingsgate was suing Thailand for 30 billion baht, which is more than 1 billion Australian dollars. And because of the international pressure because of the pressure put by the international arbitration and the impossibility of the Thai government to provide this amount of money to Kingsgate, the mine reopened on 21st March 2023. So what happened? So the court found contaminants leaking from tailing storage facility one, which is where the waste where the first piece where the waste was being stored, and so the evidence identified that cyanide, arsenic, manganese, and iron were found, and the complainants and the contaminant was spread through water, soil, and air. The consequences were profound because there was agricultural land became contaminated, canals and reservoirs became polluted, communities lost confidence in the safety of the food, blood testing revealed elevated levels of heavy metals in villagers' bodies. The impact were not only physical, the court also recognized mental suffering and anxiety experienced by communities living with contamination for years. And so this is really important because environmental litigation often focuses only on environmental damage. But in this case, the court recognized that contamination also affects people. And so this was not only an environmental case for us, it was really a case about health, livelihoods, dignity, and the right to live safely on one's own land. So here you can see, the negative impact on villagers' physical health. So what remedy did the court award? So as you can see, the court awarded compensation according to levels of exposure and available evidence, of course. So the highest amount awarded was 235,000 baht to children whose blood test showed elevated heavy metals above the threshold. And adults with elevated heavy metals received 135,000 Thai baht. So you can see the equivalent on the table that I'm sharing in Australian dollars, USD, and euros. Considering that the villagers have been suffering the harm since 2001 and have been fighting more than a decade long, legal battle, we do not consider the compensation to be enough. Importantly, the court recognized multiple categories of harm. The court recognized the physical harm, the mental suffering, the medical cost, occurred by the villagers, the food and water cost because they could no longer, use land, use the back then fertile land to earn a living, so they had to incur food and water cost, and also because the government did not provide safe water to the villagers. And the court also recognized the environmental resource loss. However, for 20 years of damage and more than a decade of legal battle, the amount recognized for medical cost is only 5,000 baht, and the amount recognized for living costs of food and water costs is only 5,000 baht. Same for environmental resource loss, only 5,000 baht per person. So this matters because historically courts often recognize only direct physical injury, and here the court recognized broader dimensions of environmental harm. The recognition of the harm, the liability is important, obviously. And so the court recognized that environmental harm is not only about pollution anymore, and it is also about fear, loss of livelihoods, and the loss of safe food and water. So there was remedy, of course, beyond compensation as well. The compensation was only one part of the judgment. The court also ordered the closure of TSF1, the environmental rehabilitation of land and waterways, and long-term medical monitoring. But also, one of the most overlooked aspects of the judgment is that it is not only limited to the 382 plaintiffs. Other individuals who can demonstrate that they lived in the affected area up to until 2015, 2016 may also benefit from the financial compensation. So this is significant because it expands the potential reach of the judgment, and the court therefore recognize harm not only to individuals but to the wider community impacted. And so the court really did not merely compensate the victims, but it's also acknowledged, the entire community, and it acknowledged that the entire community had been harmed. But what was the most important finding for us as lawyers? It's really that the company that permits are not enough in order for companies to claim that they did not violate the environment and did not violate human rights. The company argued that it complied with EIA permits and with environmental requirements. But the court really rejected that argument. And it's really important because it's the first ruling in Thailand, and it also has an impact in the region, following the polluers pay principle. Instead, what the court did, it looked at scientific evidence. It looked at the blood test, it looked at environmental studies, and it listened to the communities. And for decades, across Southeast Asia, companies have relied on the familiar defense. We complied with the law, we complied with the EIA regulations, and so we are good. We did not violate the environment. But the court response here is very powerful because the court is clearly saying that compliance alone does not eliminate responsibility. Compliance does not equal no harm. And so a permit is not a shield against accountability. And so this may be one of the most important business and human rights lessons emerging from this case. But it's also, it was also a very, very long road to justice. This judgment did not appear overnight. The class action was filed in 2016. Manushya joined as International Human Rights Counsel in 2019. Why in 2019? Because while the class action lawsuit was filed in 2016, the court only admitted the case in 2019. And also because back then Manushya was not founded. I founded Manushya in 2017. And so since 2019, we have been following years, for years we have been supporting the communities through UN advocacy and accountability, community legal literacy workshops, international campaigning, community organizing, protection work, and a lot of financial support. So this was a marathon, honestly, because it was a marathon, but not a sprint. And access to justice is rarely a courtroom event. It is usually a decade-long struggle. So what are the challenges that we faced in this case, and we call it the corporate accountability challenge. One thing I would like the Australian audience to understand is that the biggest obstacles were not always legal. The scientific evidence was strong, the facts were strong. The challenge was sustaining. The challenge really was to sustain communities through more than a decade of pressure. The communities faced more than 40 SLAPP lawsuits. Villagers, academic, and human rights defenders were repeatedly targeted with SLAPP cases. So the objective was not necessarily to win. The objective was to exhaust. And so from the company side. At the same time, there were repeated efforts to settle the case through mediation. And settlements were also offered. Very significant settlements were offered to community leaders before the final judgment. So really for Akara and Phichit, the goal was to close the case without a public finding of liability. And so it was very, challenging for us because there was, as you can see in the slide, like for us, there was really, in addition to the SLAPP, there were pressure to settle. And there was corporate capture. For us, there was clearly influence and corporate capture. And it was challenging because some of the community leaders withdrew from being the plaintiff. And because they withdrew from playing the plaintiff, it took time, to find new plaintiff. And also we were also faced with resistance from the pro bono lawyers as well, when we were bringing the case to the international audience, when we were filing complaints before the UN, when we were engaging with the UN working group on business and human rights. the pro bono lawyers, the legal aid lawyers, were facing pressure themselves from the company, and so they were then pressuring the villagers to pressure us. And so it took a long time. The goal was really to limit scrutiny beyond the domestic litigations. And 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 as international advocacy grew, we also encounter and we were able to document more about the community manipulation and the corporate capture of the judiciary and of some of the lawyers. So corporate accountability struggles are often fought not only in courtrooms, but for us it was really struggles around in the spaces around the courtrooms. But we also had the human cost of seeking justice. And so perhaps the most painful lesson from this case is the human cost of delay. Over more than a decade, communities experienced fatigue, division, and loss. Some community leaders were approached individually, as I explained, and offered significant compensation to withdraw from the class action. And the objective was really to weaken collective action and to fragment community solidarity. And these delayed proceedings, because replacement of plaintiff took time. But the greatest loss, was that some community leaders did not live long enough to see the victory they fought for. Phichit, a respected community leader and plaintiff, died by suicide in 2023. His death occurred after years of pressure associated with the litigation. Shortly before his death, he attended court proceedings regarding the replacement of plaintiff because he became one of the plaintiffs, where he faced allegations from the company's lawyers concerning corruption and tax-related issues. And so his loss deeply affected the community, and it was really a shock for the communities and for us. Panellists, another community leader and plaintiff, passed away in March 2025, just 1 year before the judgment was delivered. So he could not even be with us, for the legal victory. And both, both dedicated years of their lives to this struggle. And so justice delayed is definitely justice denied. And some people spend their entire lives fighting for justice and never live long enough to see the lawsuit. So why would movement lowering won where litigation alone might have failed? It is really important for us to talk about movement lowering, because often people ask me, what was the winning legal argument? And my answer is always the same. The legal arguments mattered, of course, the scientific evidence mattered, the blood test mattered. But none of that would have mattered if the communities had accepted inadequate settlement, if they had withdrawn from the class action or become divided. Because clearly there was one of the goals of the companies of Akara and Kisgate, by putting pressure on the pro bono lawyers, was for the communities to settle at the mediation level. They really wanted the communities to settle at the mediation level, and I cannot disclose what was offered at mediation, but it was clearly inadequate settlement. It was even below the court ruling, and without movement lowering, we wouldn't have gotten this landmark ruling. This case taught us that legal representation alone is definitely not enough. Communities also need information, they need solidarity, they need protection, they need international visibility, and they also need confidence to reject the inadequate settlements that they were put through via pressure. So this is really what movement lowering seeks to do. It's not really winning cases, but it's really to support communities build power, agency, and resilience. And so at Manushya, that meant supporting communities through legal literacy, UN special procedures complaint, international advocacy, strategic communications and campaign, protection against retaliation, community organizing. And the impact of movement lowering really also helped communities from stop being harassed and stop being slapped, by Akara and Kingsgate, because then the companies were forced to engage with the UN Working Group on Business and Human Rights and to stop slapping the villagers. After our international litigation, the company Akara instead was reaching out to us, and asking us to ask villagers to stop posting on social media, which we did ignore the request, but it did show, the impact in terms of they did stop, the judicial harassment. And it's really important for us to understand that while the courts deliver judgment, the communities really were the ones delivering justice, and movement lowering truly matter in this case. So now why this case matters for Australia. So this case concerns an Australian-linked company. The mother company is obviously Kingsgate, and that raised important question. It raised the question of what responsibilities do parent companies owe abroad? What happens when harms occur overseas? How can communities access remedy when the harms are transnational? And discussions, are becoming increasingly important globally, and they are increasingly relevant for Australian companies operating abroad. Because human rights risks do not stop at national borders, but accountability should not stop there either. And so yes, for us, it's a landmark. It's a landmark victory, but also it's not full justice. The judgment is historic, definitely, because the court recognized liability. Villagers did not settle at mediation. The court recognized contamination. The court recognized physical and mental harm. The court ordered compensation and environmental rehabilitation. However, from the community's perspective, the struggle is not over. One of the most significant gaps concerned livelihoods. As I mentioned earlier, the court awarded only 5,000 baht for the inability to use environmental resources, only 5,000 baht for the need to purchase alternative food and drinking water. And so for farming communities affected for decades, this amount do not reflect the true loss of livelihood. We had therefore prepared appeal arguments seeking recognition of agricultural losses and broader economic harm suffered by communities. Unfortunately, the plaintiff ultimately did not submit an appeal. We were informed after the appeal deadline has passed. And that's the perfect example of community manipulation and community pressure and corporate capture of the lawyers. This happened during the Songkran holiday, which is our new year in Thailand. The appeal process was happening during that time, and so it was a shock, for most of the villagers because that happened also without the consent of most of the villagers. So meanwhile, the company has appealed because Kingsgate and Nakara are rejecting the court ruling, and so as a result, the case will likely continue for another 3 to 5 years. So what comes next? The litigation alone cannot deliver complete accountability and full remedy. Three pathways remain open. First is the ongoing litigation process, as I explained earlier. Second is international accountability mechanism. So we are also considering submitting a complaint through the OECD National Contact Point in Australia. We are obviously continuing our engagement with UN mechanism, and the UN Working Group on Business and Human Rights will follow up with a follow-up communication to the companies. Third, potential parent company accountability pathways in Australia, including discussion around corporate duty of care. And so the struggle therefore continues. But today we can say something that communities were unable to say for more than 2 decades, and they were right. Communities should not have to choose between development and human rights, and the lesson of Phichit is simple. When communities organize, persist, and build alliance across borders, even the most powerful corporations can be held accountable. Thank you.
Thank you so much, Emilie. That was a great presentation. And it's really important to hear from you about all the different parts that was going on over the last 10 years. Now we're going to hear from Nicki next. So Nicki, this case, it's about an Australian mining company, but the case was heard in the courts of Thailand. So it's got this interesting sort of transnational element. Could you talk to us about whether this type of case is common, and could you perhaps touch on some of the legal issues that this type of case raises?
Thanks, Ebony. It's really great to be with you here, all of you here today. And thank you, Emilie. That was a really amazing presentation and incredible work on the case. So I'm really aware that not everyone on this call is a lawyer. When we were looking at the list, there's a whole bunch of people that aren't lawyers on this call. So one of the things that we wanted to do is take a step back just for a couple of minutes with me and look at some of these bigger issues around what is transnational litigation, is it common, like Ebony asked, and what are some of the key legal issues that arise? So I'll just take about 5 minutes or so to take you through those issues. So transnational litigation can refer to different types of cases. One is what we saw here in this Thai case, litigation against a subsidiary of an Australian parent in the jurisdiction where the harm occurred. There aren't a lot of examples out there about this, which makes this case particularly exciting. It's also exciting because it uses domestic legal courts, which are often more cost effective, and they deliver justice in a way that's more accessible to affected communities. Another form of transnational litigation involves suing the Australian company here, back at home, for harm caused overseas. Unlike the UK, where cases like Vendetta have developed real and meaningful jurisprudence on parent company liability, Australia's quite far behind in this respect. So this parent company type of litigation can be attractive where remedies are more enforceable in the Australian jurisdiction, for example, and the damages awarded might be larger. But the flip side is that it can be vastly more expensive to litigate. There are, however, some really positive developments in this space in Australia that I wanted to highlight, just briefly mentioning one case study. And this is the Montara class action. So very, very quickly, in 2009, oil and gas from the Montara wellhead platform, operated by a company called PTTEP Australasia, spilled into the Timor Sea and continued spilling for over 10 weeks. So the resulting class action alleged that the spill reached 81 villages in Indonesia, destroying the seaweed crops of over 15,000 farmers. So in 2016, Indonesian seaweed farmer Daniel Sander filed a class action in the Federal Court of Australia on behalf of these 15,000 individuals. So importantly for us in the context of this discussion, I'll just say the key takeaways of the case, which is that foreign nationals are entitled to bring the claim in Australia despite the harm and loss occurring in Indonesia. And the Australian company, owed the Indonesian seaweed farmers a duty of care when operating their facility. So following an appeal from that decision, the case ultimately settled in 2023 for $192.5 million, so just under $200 million. What's also really interesting for us to know is that around about the same time in 2022, the High Court of Australia decided in a case, BHP and Impin that group members outside of Australia, so in this case, Brazil, have access to Australia's class action regime to bring some of this transnational litigation. But to be successful, these cases need to meet really specific legal conditions. And what we see is that it's quite difficult to do so, which leads to Ebony's second question. So really, what are the key legal issues that we're facing in being able to bring more of these cases? And there are many, but I'll briefly flag 4 before handing back to Ebony and Keren. So the first is cause of action. So these cases are often brought in tort law. So essentially suing for damages caused by a company's alleged negligent conduct. Now, the best vehicle is often a class action, as we just heard in the Thai case, or representative proceeding. They need to be viable to run at scale, and individual claims are really expensive and not economic to run. So we know that Australia has this regime. And I think in hearing about the Thai case, it's really notable that Thailand is one of the few Asia Pacific jurisdictions to also have a class actions regime. And therefore we see litigation like this coming out of Thailand. We should note that large cases like this often require litigation funding, which brings its own set of opportunities and challenges, which we might go into. Lawyers have been using increasingly creative causes of action to bring some of these transnational pieces of litigation regarding the conduct of Australian companies overseas. For example, a case that our practice at Maurice Blackburn, the social justice practice, is currently running at the moment in partnership with Keren and the Human Rights Law Centre, is using consumer protection law to determine whether Kmart engaged in misleading and deceptive conduct about the use of Uyghur forced labour by some of its clothing suppliers overseas. Second is corporate structure. So parent companies routinely claim they have no knowledge or control over subsidiaries. Therefore, proving this level of control and establishing liability against the right entity can be really difficult in practice. I've investigated cases where you want to bring an action against a subsidiary in a foreign court, but there deliberately isn't sufficient funds being held in that subsidiary to meet a large damages award. Second last thing is choice of law. So even when a case runs in Australia, a piece of transnational litigation, courts will generally apply the law of the place where the harm occurred. Now, this might sound straightforward, but it can actually generate years of disputes. I ran a number of pieces of litigation against companies involved in Nauru and the offshore processing centres on Nauru. And we had 2 to 3 years of fights about which law applied and how it had applied. And if Nauruan law had applied, the damages payments would have been substantially lower. But it can also be a positive. It was the application of Brazilian law by the London High Court that led to the finding that BHP was liable for the 2015 Mariana Dam collapse in Brazil. The fourth key legal issue that I just wanted to flag today at a very high level is forum. So Australian courts will only refuse to hear the matter if Australia is a clearly inappropriate forum. Now, this is actually a more plaintiff-friendly test than some other jurisdictions like Canada, which won't hear the case if a more appropriate forum exists elsewhere. That's a very high-level overview of some of the key legal issues, and I'll pass back to Ebony and then on to Keren.
Thanks so much, Nicki. You've done a great job at explaining some very complicated legal issues there. Okay, so now to Keren. So, Keren, you've been involved in business and human rights litigation and also non-judicial mechanisms for many years. So I'm keen to hear your reflections on this case and its significance generally. But also, why do you think cases of this kind against Australian companies are so rare, and what can be done to address this?
Yeah, thanks, Ebony. I'll just speak very briefly about the significance of the case because I think Emilie covered that really well. I mean, it's obviously a real standout for a number of reasons. One is that it's relatively rare that cases of this kind are brought by communities in our region. Like there's been increased kind of litigation of this kind brought in the UK and the US and to an extent in Europe as well, but it's still relatively rare in our region. But even rarer is a case that goes all the way to trial and is successful in the way that this case has been. So the vast majority of cases against big companies settle before court, and that means that they very rarely set a precedent that can be used by other communities, and that jurisprudence in that area kind of develops quite slowly as a result. And you might get some rulings on kind of key legal issues that slowly push jurisprudence forward, but it's very rare that you'll get a case that goes all the way to the point of actually determining that a community has been successful and awards damages, as happened here. And I think it's particularly notable in this case, given the kind of tactics that were applied against the community, things like the decision by Kingsgate to sue Thailand under the TAFTA. I mean, all of those kind of tactics that we do see sometimes by companies in cases like this add immeasurably to the difficulties that communities face accessing justice. I think generally, Nicki spoke really well to some of the really tricky legal challenges that these kind of cases face. But I think even before getting anywhere near the courts, communities face so many different challenges just even getting to the starting blocks. And Emilie spoke about some of those things, but some different considerations that communities face really early on are, firstly, do they face the threat of reprisals either from the company or from their own government for speaking out about the environmental or human rights abuses? Is the community unified in its desire to challenge the company's activities, or divided? Is the community well organised and resourced to be able to take on a kind of David and Goliath challenge of this kind? Secondly, how do they gather the evidence that they need to prove that the violation occurred? So, for example, where police are brought in and use violence against community protesters at a mine site, and everyone knows that the company was probably involved in instigating that, how do communities prove that the company was involved in causing those harms? Or where an oil spill at sea is closely followed by the death of a community's seaweed crops on a nearby island, how do they gather the evidence to prove that the spill caused the harm to their crops? And then secondly, that they have suffered loss and damage in a context where they may operate in an entirely informal economy with few or no records of their previous earnings from their crops. And impacts on health of the kind that were found in this case are particularly challenging to prove because they often involve it often takes many years, for example, to show health impacts of exposure to contamination, as well as a range of different types of technical and scientific expertise. Thirdly, how do they find and afford lawyers to advise them? And then how do those lawyers obtain the funding to run multi-year litigation where costs alone can run into the millions or tens of millions? If the case needs to be brought in the company's home jurisdiction, how does the community identify a firm or legal organisation in another country with the right to expertise who might be prepared to take on litigation about a complex factual matter in another country? So as Emilie kind of, I think, outlined very comprehensively, these struggles for justice by communities really require enormous resilience and perseverance. And we're kind of 7 years into a legal complaint at the moment brought by communities against Rio Tinto in relation to the impacts of its Panguna mine in Bougainville. And similar to Emilie, we've had a number of community leaders have passed away already in the time since the complaint began. So absolutely echo what she said about sort of justice delayed being justice denied. So I think ultimately at the end of the day, if we want to prevent these kinds of harms by Australian companies in Thailand or PNG or elsewhere, we need much stronger regulation of companies' overseas activities and supply chains, and also much better enforcement mechanisms and pathways to justice for communities where companies are involved in causing these kind of harms. So Australia, for example, has endorsed the UN Guiding Principles on Business and Human Rights. In fact, we co-sponsored the resolution that brought those into effect. But our own legal domestic framework with respect to regulating companies' operations, and particularly in relation to companies' operations overseas, is very weak and piecemeal. So, for example, we have a criminal code that criminalises certain serious crimes committed by companies overseas, but those provisions are almost never enforced or investigated by the AFP. We have transparency laws around things like the modern slavery that require companies to report on what they're doing to address forced labour in their overseas operations, but don't actually require them to address that forced labour. So, really, if we want to see change, we should be moving in the direction of Europe and a number of other countries that are considering enforceable due diligence obligations on companies to both identify and prevent and address human rights and environmental violations. And we already apply this approach, for example, in the context of the duty to prevent foreign bribery by companies in Australia or sexual harassment in the workplace, but we don't see it more holistically in relation to human rights violations or environmental violations. But that approach would put the onus on companies to really know what's going on in their operations and supply chains and do something about it. I'll leave it there for the moment. But
thanks so much, Keren. Okay, so now we've got about 20 minutes left of our webinar. So our plan is we're going to have about 10 minutes now to do a bit of a panel discussion where I will ask some questions to our panel. And then after that, we'll have 10 minutes of answering participants' questions. So this is just a reminder, if you do have any questions for us, please pop them in the Q&A box and we'll get to that in about 10 minutes' time. Okay, well, thank you so much again to the panelists. That was a great discussion, and you've answered a lot of the questions that I had prepared already, which is great. But there are a few questions that I'll highlight now for us to discuss. So feel free, each of you, to pop in with whichever question you would like, and feel free to pass if any of the questions have already been answered adequately. So the first question I wanted to ask, this case, Emilie mentioned that the community wasn't happy with the remedy that was ordered by the court. So I just wanted to get a better sense of what do you think the community would need to get in order to achieve a remedy that would be meaningful for them? What do you think that they're looking for? And I mean, this question could go to Nicki or Keren as well, because you're both working with communities who are impacted by mining companies. What does proper remedy in these circumstances actually look like?
Thank you very much, Ebony. I think it was really clear for the community what does a remedy looks like. It's meaningful financial compensation in of the loss that they have occurred. Like a lot of villagers have had to move out because they were no longer able to cultivate the land. They lost. These were all farmers, right? And so the land was contaminated, which means that they were no longer able to cultivate on the land. So there was a huge loss of livelihood, and the government did not provide any alternative trainings, or it was either people have to join and work in the mine, or they have to move out. And so for the communities, they did provide an amount that they wanted. The Did you provide a specific amount in mediation that I cannot provide because it's confidential and I don't want to be sued by ACARA and Kingsgate if I provide it here? But it was way above what they were able to win in court. Just as an example, what the pro bono lawyers put in the petition in court was the double of what the court has ruled in favor of the villagers. And already, when the pro bono lawyers put those amounts in the petition, so as you see, 235,000 Thai baht for children below 15, 135,000 Thai baht for adults, for those who have heavy metals above the threshold. That's what the court ruled. But the lawyers had put in the petition the double of that. There was already challenges between the villagers and the pro bono lawyers, us and the pro bono lawyers, because we did not agree with the amount that they were pushing forward. So what the villagers were asking were 3 times of what they initially asked for, and I think it will be impossible for the companies for the company to fully restore the environment and to fully give them back what they have lost. And the fact that Kingsgate and ACARA are rejecting the court ruling, they really think they are above the rule of law. Their behavior and the feeling of the feeling that they have that they don't have to, that they are allowed to overlook, that they're allowed to have an opinion, But the fact that they are so confident, and when you read the press statement, it's so arrogant, When we read it, we're like, oh, the audacity. It's clearly because the Thai authorities also enable them to feel so powerful because of the international arbitration and the pressure that Kingsgate was able to play, the pressure that Kingsgate was able to put, on Thai authorities trying to avoid the international arbitration. It really gave them the impression that they were above the law. There are things that I did not share during my presentation was the number of awards, that Kingsgate and ACARA received by Thai authorities. They are doing a lot of CSR activities, and they are trying to frame CSR as corporate accountability in Thailand. And so they have been, protected and supported by Thai authorities since the reopening of the mine. And so really what true remedy would look like is the amount that the villagers want. To be very honest with you, when we came out of the court, we were very happy. Obviously, as lawyers, we were happy because we supported the community to resist. We really wanted to create a legal precedent and not settle through mediation. It was still below what the company was willing to give in mediation. But half of the villagers were not satisfied. Like for them, they're like, okay, the lawyers, you're happy. You got the liability, but we don't care. We didn't get the money that we wanted, And so from a villager's perspective, it's really the financial loss, is really the loss of livelihood that mattered more than the legal win. As lawyers, we can be super happy about the legal win. Yes, we created a precedent. We hope it's going to influence, people in the region and other communities in the region. But from a villager's perspective, the legal win, it was not necessarily meaningful for most of them because they did not receive the full compensation that they were hoping for.
Yeah, I think just adding on to what Emilie says, I think this is a common problem, and it's not only even where communities achieve a successful settlement. Obviously, compensation in and of itself often doesn't make up for the harm that has been experienced, and this is one of the kind of problems with, I guess, the legal process and the way it kind of channels things, I guess, towards an outcome that is really just about compensation. In some cases, rare cases, you do see courts order cleanup, for example. That happened, for example, in the Shell case in the UK courts. That's also what we're currently trying to achieve with working with communities in Bougainville, is not compensation so much from the company, so much as remediation works to actually address the ongoing harms that people are experiencing from environmental pollution, from dangerous, collapsing infrastructure and levees, from ongoing destruction of their land. So compensation doesn't really work in a context where you've got ongoing violations of people's rights. You really need to be able to have a remedy that puts people in a position that their rights can be protected. And often another thing that's really important for communities is some form of recognition or apology from the company. And again, that can be something that's very difficult to achieve through a legal process.
I'll just add to that very quickly. In addition to all those, an example of something we're asking for in a case at the moment against an Australian mining company is putting in a consultation framework. So pay compensation, do environmental remediation that Keren just mentioned, but also set up a consultation framework going forward of how you want to work with the community on your mine.
Thanks, everyone. Okay, another question. The case that Emily's talked about today, went for 10 years. And I know from, Keren and Nicki's practice as well that the cases they're involved in take many, many years. So these are very difficult and long-running campaigns. How do you resource and sustain those types of cases over such a long period of time?
It's challenging. Honestly, you need to find funders who are willing to believe in your ability to mobilize the communities and to win a case in the long run. We didn't we supported the communities in order to be able to continue the class action lawsuit, because once the court once the court accepted the class action lawsuit, we had to pay different legal fees, and we also had to support financially the villagers to come, to Bangkok all the time for the court hearing, but also to support the lawyers' trips as well in order to collect evidence, and ourselves, to go in the field. It does require a huge amount of funding. It's not easy, and sometimes we didn't have lawyers for several years. So it also means that you do it pro bono. You do it in addition to your normal or usually work plan, but it does require a lot of funding, especially to do legal empowerment training, to do advocacy, to do international advocacy, but also campaigning online. Thank God, there are like free websites like Enva and things that can help you, do campaigning or do nice visuals. But in the end of the day, you need to be able to have the public on board. You need to be able to convince your donors that you will be good international lawyers, that you will be able to mobilize the communities. And it also helped me answer one of the questions, because I see that Juanita from Trust Law asked a question. It's how do you keep the community aligned and motivated in the midst of the threats, and as well as settlement offers. Honestly, if we didn't have what was helpful also is to have a lawyer on site. So it's to have a community lawyer from Phichit on site, to be able to always communicate with the communities and engage with them and meet with them. What was helpful, of course, was to have the financial support, so being able to financially support them to always come to court. But it's the constant communication, and it's to build trust. I think what is really, really important is to build solidarity, and also have a strong understanding of what true solidarity means. And for us, true solidarity meant deferring power to those on the front line. So really listening to the community needs and really what they wanted out of the case. It was to second agree to disagree. Like some community members did not agree. Some of them were manipulated by the companies, and to build solidarity and to stand with them and to say, okay, if some people withdraw and if some people disagree, it's fine. Like we can still move forward and agree to disagree. Third was to embrace differences and embrace different opinion, but always coming back to difference of what the community wanted. And so what you need, it's of course financial support, but it's also build trust with the communities, show them that you will always stand with them, that you will always be in solidarity with them, even if there is no funding, and always be available for them, like have communication channels, answer the questions, and always be there. They have fears. And we also had fears. I'm going to be very honest with you. More than one time, we were also worried of being slapped, by the companies. When some community leaders were asked to withdraw from the case, they were also asking us to withdraw all of our public communication from our website. So we explained to the company that this was our intellectual property, and everything was so through consent. So if the company had an issue with our content or what was on our website, they could sue us. But it's showing courage, making sure that the villagers are courageous. It takes years, but trust and solidarity is really what keeps you going. Building trust with donors as well, and forcing donors to also stand in solidarity with the communities and to keep funding the case.
Thanks, Emilie. Just noting the time, we've got less than 10 minutes left. So I'm just going to turn now to our audience Q&A and ask a couple of questions from there. I might ask, a couple of questions at once, just in the interest of time. So one question was asked about the court's reasoning on the quantum of compensation. So how was that calculated? Was that based on evidence, and was the evidence accepted by court, or is this an indication that the court's processes were inadequate in regards to the compensation amounts? And another question, and a lot of these questions are to Emilie, so I'm sorry to Nicki and Keren. But another question is, looking back, now that the litigation is over, well, at least the first part of it, was there any lessons that you learnt from that process? So was there anything that you would do differently, or things that we can all improve on in our practices for future?
Thank you very much for the questions. Thank you, Shanta, for your question. It's nice to see that you followed the webinar. So the court methodology focused primarily on categorizing the victims according to age and the levels of heavy metals found in their bodies. Compensation was then allocated according to predefined categories of physical harm, mental harm, medical expenses, food and water cost, and loss of environmental resources. And so, yes, the court clearly accepted the scientific evidence establishing contamination, causation, and harm. And in fact, one of the most significant aspects of the judgment is that it relied heavily on scientific studies, and the blood test and environmental testing and community evidence. However, the court did not fully accept the broader economic consequences experienced by the communities, and particularly agricultural losses and long-term livelihood impact. And so this is where we believe there remains a significant gap between the recognition of the harm and the effective remedy. And I would say that the court failed to recognize I would not say that the court failed to recognize the harm, but on the contrary, that the judgment is groundbreaking in recognizing liability and environmental damage. But I do think it raises important questions about how courts quantify long-term environmental, livelihood, and intergenerational harms. To be very honest with you, we knew that it will be difficult for the court to not recognize liability because of all the international pressure and engagement by a UN mechanism on this case. So we knew that the court would not try to challenge that. So our worry has always been the compensation level. And how can we challenge the court in terms of the compensation level? That's why we were hoping that the villagers would appeal the case. And, when we met with the villagers, they were really willing to appeal the case in order to get better financial compensation. In terms of whether the court processes were inadequate in this regards, to be very honest with you, I don't think that the court processes were inadequate. I do feel that there is a corporate capture of the judiciary. On one side, the court could not avoid recognizing the liability, and they did it. But on the other side, the only thing that the court could do under the pressure of the company was to lower the environmental harm, loss of livelihood, the economic loss, and international loss. This is in the power of the court, and that's how they calculate it. The other question was what we hope we would have done differently. Well, what we hope we would have done differently, I hope I had founded Manushya before, so we could have been the lawyers of the communities at the national level as well. I think that was one of the biggest challenges that we have to face, is that we were not the direct lawyers, but we were the international human rights lawyers, and we It was not easy as well for us, coming in, and there is a lot of hierarchy and respect that we have to pay to senior lawyers, and with huge reputation in the country, it's difficult to to officially challenge when we feel there's corporate capture or corporate influence with pro bono lawyers, and we didn't often see eye to eye. So I think what we would have done differently would have been to be the lawyers from the very start, from the very beginning. We hope that then, and to bring the case at the international level since the very beginning, because then we would have hope, that it would have protect the communities better. Also, many of us were still students, and some of my team members were just born, when the mine was open. The mine opened in 2001, and so in 2001, many of us were still in law school, or some people in my team were born in 2001, 2005. So some of them were babies. So I think we wouldn't have been able to protect the communities against slap lawsuit, but I think now we are trying our best to denounce Thailand as the top country in Asia in terms of slap lawsuits. Thailand is always known to be a champion on business and human rights, but we also need to acknowledge Thailand as a champion on slap cases, especially in the business and human rights context.
Thanks, Emilie. Okay, we've only got 1 or 2 minutes left. So to end, I always try and end webinars on a positive note, or looking towards the future. So I'll ask each of our panelists if they could just briefly give us a thought about what could we do into the future to strengthen business and human rights accountability. Yeah, in Australia, in the region, for Australian companies operating around the world. Yeah, go for it. Nicki, you're off mute first. Do you want to go first?
Two really quick things. I think there's a real access to justice gap in Australia between cases like Montara that are worth $200 million because it was commercial seaweed farming, and then cases where there's really serious harm, but it's not commercial, it's not a large amount of money. And I think we've got a lot of work to do on how we fund those cases, how we as lawyers make sure we can litigate those cases. And I'm really keen to keep looking at that. And also, I'm always conscious that companies they've got oversight of everything that's going on, but communities don't. And so building those networks at the grassroots level, which I think there's some really exciting stuff going on around that network development so that we can all learn from these cases and fight back.
Thanks, Nicki.
I can jump in. I do think it's a hard question because there's a range of different things that need to happen, and in improving that, in part, the actual pathways to justice and the ability, in particular in terms of the cost barriers to people bringing these kind of cases, is a huge one. I think ultimately, though, we want to be preventing these kind of harms from happening in the first place. So I think we need to be creating legal frameworks that actually ensure that companies are taking action early on before harms occur, to try and set up their operations and things in a way that means that these kind of harms don't happen in the first place. And that requires a whole range of different measures, but I think I outlined some of them. I think it requires a duty to prevent these kind of harms on companies. It requires penalties. It requires looking at things like directors' duties as well, in terms of shedding liability home at a personal level to directors of companies, so that they take these things seriously.
Thanks, Keren. Emilie, did you have any thoughts on how we could strengthen business and human rights accountability?
Yeah, well, I think it's really important to move from voluntary measures to mandatory measures. For many of us, we've been working in the B&HR space and using the UNGPs. We push for national action plan on business and human rights. Now many of us are pushing for human rights due diligence legislations. So definitely have a strong legal framework, but more importantly, really understand that corporate accountability it's not a tick the box exercise. And I think what mattered in this court ruling is that's what the court rule is, that it's not because the company followed administrative process related to EIAs that the company can avoid liability. And now we are seeing the move globally to human rights due diligence, and there's this worry that human rights due diligence framework also going to be weaponized by companies, misused by companies as another tick the box exercise stating that they have prevented harm because they followed all the different processes of due diligence, but still the harm is occurring. So I think we also need to look at stronger legal frameworks. Most of the due diligence laws that we are seeing globally are mainly including administrative penalties, and it's not enough. We really need civil and criminal liability. In the case of Thailand, we cannot only use, the civil tort law. Civil liability under the civil tort law is not enough, as we can see in this class action lawsuit. So we need strong legal framework. We need to move from voluntary measures to mandatory measures, and we really need to also include civil and criminal liability on top of administrative responsibility.
Thank you. There's some really important ideas there. Okay, we've unfortunately run out of time. I feel like we could keep discussing this topic for another few hours. So I just wanted to say thank you again to our panelists, Emilie, Nicki, and Keren. We really appreciate your time and generosity in sharing with us. And thanks to all of the attendees for your interesting questions and for joining us and being part of this discussion. Please stay connected with the Business and Human Rights Access to Justice Lab. You can find us on LinkedIn or on our website as we put on these events every month or so. So join us at one of our future events. So thanks again and have a great afternoon.